I'm criminal defense attorney Aaron J. Boria, and today I'm going to answer the question, what happens when I'm charged with a crime? Being charged with a crime can be incredibly confusing, frustrating, and scary. So today, let's answer that question in this short video. Again, I'm criminal defense attorney Aaron J. Boria, and whether you've been charged with a crime in Manistee or Melvindale, the procedure is pretty much the same. The first thing that happens is you're going to be either issued a ticket, you will be arrested, or a warrant will be issued for your arrest. The next court hearing that comes after that is going to be the same no matter which type of those contacts happened. You'll be arraigned. That's the first time you go to court, is your arraignment. At arraignment, the judge has two jobs. He has to tell you what you've been charged with. That also includes the maximum penalty for that offense. And the judge has to set a bond. So the first thing is pretty simple. The judge just reads the charges to you off of the sheet that the prosecutor has signed, and the judge sets a bond. Sometimes a bond confuses people, but in simple terms, it is just a promise to come back to court, usually secured by money. So if a judge says your bond is going to be $1,000, you would pay $1,000, you leave the courthouse, and then you come back for the next court date. More and more judges are issuing personal bonds. If a personal bond is issued, you don't pay any money. The judge might say $1,000 personal, you don't pay any money, you leave the courthouse, and you come back for your next court appointment. But if you violate your bond conditions or you don't show up, then you would owe the court that money. After your arraignment is your pretrial. Your pretrial is where your attorney will meet with the government's attorney, the city attorney, the state prosecutor. They're on the side of the police and they're there to prosecute you. Your attorney's job is to try to negotiate with them a reduced charge, a dismissal, something of that nature. If a dismissal cannot be achieved, if there is no plea agreement or you don't like the plea agreement, then after that pretrial, it is possible that your attorney may challenge the law with a motion, such as challenging things like probable cause, reasonable suspicion, or they may have an evidentiary hearing. An evidentiary hearing is similar to a motion, but testimony is involved. So an officer may be called to the stand, swear to an oath, and answer additional questions from your lawyer. At the end of that evidentiary hearing, it is possible that your case could be dismissed, it could be reduced, you could get a better plea deal, any of those things could happen. If after the pretrial there are no motions to be filed, there are no evidentiary hearings to be filed, you do not take a plea and the case isn't dismissed, you have to go to trial. There are two types of trials. There is a bench trial. This is a trial with the judge, where the judge decides both the legal issues like probable cause, reasonable suspicion, whether or not testimony is hearsay, and also decides the factual issues. The factual issues are the dispute. So in a domestic violence case where maybe one person is claiming self-defense, the other person is claiming domestic violence, and it's a he said, she said case, the judge has to make a decision. If it's some kind of car crash and one party says the light was green and the other party says the light was red, the judge has to decide what color the light was. The other type of trial is a trial by jury. That is where a jury of your peers, 6 in a misdemeanor case, 12 in a felony case, they will decide the factual issues, what color the light was, who's telling the truth in an assault case. The judge in a jury trial will still decide the legal issues. So when someone's testifying, the judge will still decide whether or not that information is hearsay, what can come in, what can't. If you are found not guilty, the case is resolved and you leave. If you are found guilty, then you will have another hearing after that. That is your sentencing hearing. At your sentencing hearing, the judge will take into consideration the charge as well as the person you are. There's usually an interview before that to get more information about you. And then at that point, you would be sentenced. In any criminal case, there is always the possibility of jail, but it depends on the type of case as to whether or not you would likely get jail as part of your punishment. Many people are put on probation and they don't ever see a day of jail. I'm criminal defense attorney Aaron J. Boria, And if you've been charged with a crime, call me today, 734-453-7806, or shoot me an email at borialaw@gmail.com. I have defended people across the state of Michigan, from the Lower Peninsula to the Upper Peninsula. I have achieved countless dismissals, not guilty verdicts, plea reductions, you name it. So if you've been charged with a crime, call me today, 734-453-7806, or shoot me an email at borialaw@gmail.com. I am happy to fight for you.